we were starting with.
But Mr. Silver is on Zoom too, so.
He's on Zoom. Okay.
Yeah.
Okay.
Excellent. And it's not mine naturally, right? That's fine.
All rise. 14A District Court for County of Washington, State of Michigan is now back in session. The Honorable Day 7.
You may be seated. Do we have it now?
We don't have any money. We're gonna run out eventually.
That's right. Court does call the case of the people versus Sean Ode.
Conrad Siller on behalf of Pittsfield Township.
Good morning, sir.
Good morning, Your Honor.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Odom Jr., who may be present via Zoom.
Don't have them checked.
Do we have him checked in? Odom, not here.
So, Your Honor, I believe I might have a half explanation for his failure to appear. I was of the belief that my client was in the Washtenaw County Jail until yesterday. However, the Sean Odom in the Washtenaw County Jail is my client's father. So that being said, I did not attempt to contact my client out of custody until yesterday afternoon. His phone number is disconnected. However, I did have a good email address to which he responded asking for the court code. I did provide him with the Zoom information, I believe just this morning. Given that, and I believe it will partly be my fault, I would ask for an adjournment of this case.
Well, if he shows up, I'm willing to recall it, but this time I'm going to issue a bench warrant. Bond 10%.
Thank you, Your Honor.
Court calls the case people versus Andrew Party.
Conrad Siller on behalf of Pittsfield Township. I believe there's two cases for Mr. Party, Your Honor.
There are two attorneys too.
An assistant Public Defender Natalie Pate with and on behalf of Mr. Andrew Party in the case ending in 1090.
Good morning, Honor. Charlotte Steffen on behalf of Mr. Party and the case ending in 0621.
Yes. All right. What are we doing, folks?
Your Honor, the prosecuting attorney has extended an offer or a couple of offers to Mr. Party, and I understand that he wants to accept the offer in which he would be pleading guilty in one case. The other case would be dismissed, and the one he's pleading guilty to would be a deferred sentence, if I understand the offer correctly.
That is the offer, Your Honor. I suggest he pleads in the more recent case, which would be 1090.
So he'd be pleading to the possession of drug paraphernalia.
Correct.
And I have no form on that, right?
That is correct, Your Honor. I did meet with Mr. Party yesterday morning, and he indicated he did not want to plead in my case at that time. I understand that there might have been a change in that.
So
my request in my case would be for then a brief adjournment, given that development, Your Honor.
Well, if he wants to plead, to the older case, I'm okay with that.
But the problem is that he's indicated that he didn't want to plead in that.
In my case, correct, Your Honor.
I was confused on what was going on when I'd spoken with her. I didn't know. I just wanted to know. I hadn't spoken with my other attorney. So I just wanted to know what was happening in both cases before I made a choice. And
Okay.
After I'd spoke with her.
Is he held on anything other than this?
No, Your Honor. He's held on these two cases because of the remand on the bond violation.
Oh, I know. I know why he's here on my cases, but there was not anything else he's held on. All right. So what does he want to do, Green?
Do you want to plead guilty on the case?
I was going to plead guilty on the case, and I was hoping to be released.
All right. So we'll then have him plead in 621. And then the other one will be dismissed because of the conversation that he had with you, Ms. Payton. That way there's no. I'll probably need a form at some point. Maybe not. All right. May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
State your name.
Andrew Party.
You can bury it under objections, twist it through legal language, or drown it in paperwork. But truth has a nasty habit of resurfacing. Every witness who takes the stand gambles with exposure. Because once the oath is sworn, lies become landmines, and the smallest detail can blow the entire defense apart. Watch closely. The truth is always leaking.
Sir, it is this court's understanding you're going to plead guilty to the charge of possession of drug paraphernalia under the Pittsfield Township Ordinance. That's a misdemeanor, punishable by up to 90 days, $500 fine plus court costs. You understand that?
Yes, sir.
Understanding that, still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
You understand that by pleading guilty, you'll not have a trial of any kind. Had you previously, yeah, that's a problem. Have you executed an advice of rights form?
He has not signed it, Your Honor. However, I did review it with him.
All right.
Would you like him to sign it now, Your Honor?
Yes.
I got a date.
That's fine.
You got that advice of rights form. You have any questions regarding any of those rights?
No,
You'll see on the podium, look at paragraph 5. Those are your rights which are part of a trial. You understand that you're giving up those rights
yes, sir.
by entering this plea. Does anybody promise, you understand also you're giving up your right to appeal of right?
Yes, sir.
Anybody promised you, are you on probation or parole? I'm sorry.
No, sir.
You're not? Has anybody promised you anything other than what's been stated here today to get you to plea?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily,
Yes, I am.
of your own free will,
All free will.
and because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
Find my ticket in this case. On the date of May 18, 2025, at location of Carpenter Road in Pittsfield Township, Washington County, State of Michigan, did you have drug paraphernalia in your possession?
I believe I did. Yes, sir.
Did you have a syringe and used crack pipes in your possession, sir? On that date?
It was in the car. Yes. Yes, Your Honor.
Okay, and were you in the car?
Yes, I was.
And were these items yours?
Yes, Your Honor. I guess
Well,
that's complicated. I knew they were in the lug. I just knew they were in the luggage. I didn't take them out. So, but I knew they were there. So yes. Oh, I knew that was there. Yeah, same thing.
Yeah, Your Honor, if I can help clarify. One, because the case of Ms. Pate involves a car. The case that I represent him on involves a hotel room. So I think he was just confused on when you said car.
They're both by the same area.
May I have a word here, Your Honor?
yes, you may.
All right. So in the hotel room, you had a bag or luggage with you,
Yeah, yeah.
and there was a syringe in your
Oh,
bag.
yeah. Yes,
Is that correct, sir?
Yes.
Okay. And you knew it was there?
Yes.
All right. And you used that syringe for the purposes of taking narcotics of some type. Is that correct?
Yes, Your Honor.
All right. Sir, I do have to advise you if between the time of my acceptance of your plea and the time of sentencing you commit misconduct as defined in the Michigan court rules, the court would not be bound by any sentence evaluation and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor.
No, Your Honor.
All right. And have I complied with the court rule?
Yes,
You
Your
have,
Honor.
Your Honor.
All right. In case 621, court will accept the defendant's plea of guilty. In the other matter, that case is dismissed pursuant to the plea agreement.
Your Honor, I can file a nollie process if that would. Oh,
Yes, please.
all right, I will.
If you will.
Okay, I will.
Okay. And on this matter, I had revoked your bond. Anything you want to say before I do impose sentence, or you want me to set them for sentence?
I have people that are in my hotel room. I went out. I've been trying to get there with all my belongings, and my anxiety's been going through the roof. I don't know what they're doing with my belongings. I'm afraid they could all be gone, and everything I own is literally there. And I would do anything if I could get there to find out they're even in my hotel room still. I got stuff worth almost $100,000. Like I got a brand new bike.
He's
Everything's
just
just-
trying to ask if Your Honor will release him today is where he's going with this.
Thank you.
I got a vehicle that's sitting at this hotel. I don't know if my vehicle's there anymore.
How long has he been in? He's been in.
Like 40 days, I believe. It's been over a month.
I believe it was since September 17th, Your Honor.
Yes, it is. I see it. He's 15. Fines and costs of $250. I'll make that due and payable by December 31st, 2025. 90 days of jail credit, 30 served, the balance is suspended.
Thank you, Your Honor.
Thank you.
Your Honor, do we need to address the bond violation? There's also,
There was a bond violation, but do you admit to the violation?
Yes, yes, sir.
I'll sentence him to 30 days, credit 30 served on that.
thank you.
Your Honor.
All right, thank you. Yeah, can you have a hand wave? Court calls case People versus Sharon Abbott.
Ashley Phelps for the people.
Sherilyn Foster Tucker on behalf of Sharon Abbott.
Good morning, Your Honor.
Your name?
Sharon Abbott.
Thank you. What are we doing?
Your Honor, we're just asking for an adjournment. I'm hoping to give the prosecutor some information, so maybe a little bit longer of an adjournment if possible.
November 19, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Court calls the case of the People versus Jacqueline Murray.
Ashley Phelps for the people.
Edward Drooks for Jacqueline Murray.
Jacqueline Murray.
Thank you. What are we doing?
Your Honor, I'm asking just for a brief adjournment.
To November 5th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Court calls case People versus Mutada Al-Khalaf.
Ashley Phelps for the people. Good morning, Assistant Public Defender Lauren Kearney on behalf of Mr. El Kalfa Murtada. Yes.
Can you state your name, please?
Murtada Al-Khalaf.
All right, you need to turn a camera on, please. All right, thank you.
Your Honor, we are requesting an adjournment. My client has
Go ahead.
an appointment at Secretary of State on Monday to
On Monday?
get his license. Yeah.
Oh, to get the whole license, you think?
Well, actually,
Or does he just starting a process?
I should clarify, yeah. Do you know if you're gonna be receiving your license on Monday or just they're gonna tell you what you need to do to clear it up? I can't remember, I apologize.
Give me some information on what I need to do.
They're going to be giving you some information on how to get your license? Is that what's happening?
Yeah. So I'm still waiting
Okay.
on what they say.
November 19, 2025, 9 a.m. We'll try to figure out where he's at that point. Okay? Thank you.
Thank you.
Thank you, sir. Court calls the case People versus Deanna Conrad.
Conrad Seller on behalf of Pittsfield Township.
And Ashley Phelps for the people.
Assistant Public Defender Natalie Payton on behalf of Ms. Conrad, who is approaching. Please state your name for the record, ma'am.
Deanna Conrad.
Thank you.
Thank you, Your Honor. Today's the date and time set for a pretrial hearing, and I'm also prepared to address the bond violation, if the court would prefer to start with that.
Yes, wait a minute.
Thank you, Your Honor. So I did receive the violation report. I'm sure the court is in receipt of, where my client
Go ahead.
My client did test positive or did consume alcohol while on bond.
Yes.
She admits that both to community corrections and to me, and she does admit the bond violation today. When I did initially get this report and speak with Ms. Conrad regarding the violation, she was immediately forthcoming with me. I did then advise of the warrant, and then she did, under my advice, turn herself in on that warrant this morning. She does take full accountability of the fact that she did consume alcohol and does apologize to the court. She is asking if the court would consider releasing her today, given the fact, and she does recommit to her sobriety and acknowledges, or to me, that she will not consume any further alcohol while on bond. This is a case from 2018. My client does have full-time employment. She works as an inspector for Real Truck, and she is hopeful.
But she didn't even, hold on. I mean, I'll listen to you. Really? That's like the fifth time.
Not rolling the next one.
What?
Your Honor.
No, I mean, bless you. That's what I meant to say it that way. In this case, she was a 2.55 and a crash. And so while you're talking the time between when that has occurred and where we are now, that's fine, except that then she doesn't make it very long once the conditions are put in place and she's drinking.
She does admit that she drank while on bond, Your Honor, and does take full accountability for that and does apologize for that. It is my understanding, I can't make the representation for sure, but it's my understanding that since this alleged offense in 2018, that there has been no further similar type of conduct. I don't know that for a fact. That is my understanding. However, she does acknowledge that she did violate her bond in this way. I'm asking that she be released today. I believe her to be put on the scram tether, and that she can come back for an adjourned pre-trial date to prove her or show that she does take her compliance seriously to the court. She was always very honest and communicated with me and wanted to take full accountability for her actions. And she did turn herself in this morning on this warrant. And she is asking if the court would allow her to be released.
Right, but wasn't she on a scram before?
Yes, Your Honor.
Well, so, all right. I mean, I'll hear you out, counsel, but I don't know. Why would I release her under the same conditions when in very short order she had violated why would I do the same thing again?
I understand the court's concern, Your Honor. Ms. Conrad, this was a wake-up call getting this warrant. She takes it seriously and did turn herself.
It wasn't a wake-up call just being present in court telling you not to drink?
Your Honor, I believe this was a harsher wake-up call. And I would just ask if the court would consider letting her out and giving her a chance. And I completely understand and Ms. Conrad is fully aware, if she were to violate in any capacity again, in all likelihood, her bond would be revoked until the pendency or till the end of this case.
How did she get here to turn herself in?
Pardon me? How did she get here to turn herself in? I don't know for a fact.
Can I speak? I'm sorry.
How did you get to the jail?
I was dropped off.
Oh, by
my roommate.
Your Honor, her roommate dropped her off at the gym.
May I ask a question, Your Honor?
Sure.
The violation report the court is reviewing, is that dated October the 4th?
I do have an October 4th report. That's the one that I'm looking at.
I was confused because when I review this, it says on the second page that the defendant denied alcohol consumption and said he used cough syrup.
I know.
Okay, I'm sorry. I wanted to make
No.
sure. I had put it differently in court, so I was concerned that there was a revised report that I hadn't received.
Correct.
We'll let the court know as well. There was a 2010 prior offense, so this is at least the defendant's second.
That is correct, Your Honor. She admitted to her first violation of drinking a glass of brandy to community corrections, and then did admit to consuming cough syrup, which technically usually has alcohol in it, and they're provided at community corrections that they should not consume.
Did you really drink cough syrup?
Yes, she did.
You did?
Yes. Well, actually, it was Alka-Seltzer plus.
Okay, so what are we doing on the case?
I'm asking for an adjournment, Your Honor. My office has not yet received media discovery in this case. I have requested it from the people.
Both of her cases will be adjourned to November 5th, 2025, 9 a.m. I'm just, so it's really two violations all at once, in essence. I mean, because it told her not to drink, she drank. Right? And then, I guess presumably then has cough medicine that she can't have while she's on bond. And they go through, you hold your hands up like you didn't know that. They go through that with you. You can't have anything that has any alcohol.
No Alka-Seltzer Plus.
Your Honor, we are not at all skirting the first violation at all, the alleged one, and Ms. Conrad states to community corrections and to me that she'd consumed liquor brandy on that day. My client is telling me that the report about the cough syrup allegation, and I understand what Your Honor is saying, and I do understand that community corrections provides that information. Ms. Conrad is now telling me it was Alka-Seltzer Plus, and she did not know that may have alcohol in it. But she does acknowledge that first violation, her very first one, and she was immediately honest with community corrections.
Yes.
In the water?
Yes.
That's not cough syrup.
Cold medicine. I said I took cold medicine.
A courtroom doesn't just reveal who's guilty, it reveals who we are. Every decision reflects our fears, our biases, our need to see order in chaos. Sometimes the verdict says more about society than the defendant. Justice, after all, is just a reflection of the people who demand it.
Your Honor, my client is stating to me that
I questioned Ms. Conrad about the alcohol detection. She denies consuming any alcohol and states she used cough syrup.
Cold medicine.
Your Honor, my client.
So now you're saying you said something different that's in the report?
I'm saying I said cold medicine. I didn't say cough syrup. I said cold medicine.
So you're saying, but you denied consuming any alcohol, but now you're telling me that, huh?
I never denied consuming alcohol.
Your Honor, I believe she's referring to the brandy event that immediately she did admit that she had consumed liquor on that day.
She says, it says here, I questioned Ms. Conrad about alcohol detection. She denies consuming any alcohol. She states she used cough syrup. Where's her admission to the brandy?
On the first page, Your Honor, it states, I questioned Ms. Conrad about this alcohol detection, and she admits to drinking a glass of beer.
Right.
That was after the first alleged violation.
Right, and then there's another one.
30th.
And so on that one, she says she wasn't drinking.
Correct.
And that she had Alka-Seltzer Plus.
That is correct, Your Honor.
Or something in water that
Your Honor, ultimately, Ms. Conrad completely acknowledges she drank brandy. And that
on the one day.
Right.
But here's the problem. If you're an addict and you're telling me on one day, yes, I did it because I got caught. But then comes the next time and you start going through what is the natural thing for most addicts, a denial. saying that everybody got everything wrong. I didn't have any alcohol. It's coughs. I had Alka-Seltzer Plus. So you're saying Alka-Seltzer Plus came up as a positive?
I can't speak to that, Your Honor, but what I can speak to is that Miss Conrad was enrolled on this in September 4th. She had a drinking event on September 30th. This was her first contact from Community Corrections about the drinking event, to which she immediately admitted to drinking liquor. She didn't try to make any excuses or say that it was cough syrup, cold medicine, or anything. She was 3 weeks into her bond, just shy of 3 weeks. She drank, she violated her bond. She takes full accountability to that with both the court as well as to Community Corrections. She did then have another event that the Scram Tether picked up on October 3rd. She states to me that she, yes, agrees with that part of the report, that she denied consuming any alcohol. She states to me that she told Community Corrections she took cold medicine. And of course, if that had any alcohol in it, she would not be allowed to do that as to bond, which she now understands. She does admit to drinking
while she's telling me it's Alka-Seltzer Plus.
As to the second event, yes, Your Honor. And she admits to the first one in complete honesty.
I'm going to let you go ahead because I'm about so done right now.
She's taking accountability for the bond violation, Your Honor, and she's asking that the court release her
She's
today.
taking half accountability. She's not taking full accountability.
So if I say I drink alcohol, will it make a
So here's what I'm going to do. I'm going to adjourn this to November 5th, 2025, 9 a.m. for a sentence on her violation and pretrial. Her bond continues as denied. Thank you. Court calls the case, People versus Jeffrey Ostermiller.
Asheville, people. Good morning, Assistant Public Defender Lauren Penny on behalf of Mr. Ostermiller. Say your name, sir.
Jeffrey Ostermiller.
Thank you.
Now, I am requesting an adjournment. Mr. Ostermiller got me a lot of mitigation materials of all the good stuff he's been doing. I just want some time to get that over to people.
November 19, 2025, 9 a.m. Bond continued. Court calls the case, People versus Devontae Connor Belcher.
Asheville, people. Does she have two cases?
I do.
Assistant Public Defender Natalie Pate, on behalf of Mr. Connor Belcher, stands to my right. Please state your name for the record, sir.
Devontae Connor Belcher.
Thank you.
Thank you, Your Honor. I have two brief requests. One, as to the pretrial, I'm asking for a brief adjournment. I had the opportunity to discuss these cases with Mr. Connor Belcher, and he has proposed a type of resolution that he would like me to speak further with the people regarding both of these. And I'd also like to briefly address bond when appropriate.
Adjourn both matters to November 5th, 2025, 9 a.m. as to bond.
Thank you, Your Honor. As of yesterday, the only matters holding Mr. Connor Belcher in the Washtenaw County Jail are these two matters. These are both retail frauds, and the bonds are currently set at 1,010%, as well as a third matter, which is disorderly out of 15th District, that the bond is currently set at 1,010%. I still need to contact the public defenders in that court regarding the bond.
People don't have any objection to a PR bond?
Leave it discussion court now.
So that's
Yeah, anything else you'd want to say?
No.
Good. Bond will be reduced. $2,500 personal recognizance bond. Don't mess it up.
Yes.
Hey, come back when you're supposed to. You hear me?
Sir, of course.
All right. Thank you.
Thank you, Your Honor.
He doesn't show back up. I'm taking you in, Pate. Shondell Barrett.
Good morning. What was the name? Oh, Barrett. Asheville, that's for the people. Good morning, Assistant Public Defender Lauren Penny on behalf of Ms. Barrett.
Ms. Barrett, can you state your name and turn on your camera, please?
Barrett.
Very well, she works on getting her camera on. Oh. Bless you. All right. I don't know what's going on.
Well, Your Honor, we are requesting an adjournment for plea negotiations.
Adjourn this matter to November 19, 2025, 9 a.m. Bond continued. Thank you, Miss Barrett. Can you come back on the 19th? Know how to work your camera. Court calls case People versus Ishmael Davis.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Davis. State your name for the record, sir.
Ishmael Alexander Davis.
All right, what are we doing?
Your Honor, I guess two requests. The first is an adjournment of the pretrial as we are in negotiations. And the second is in order to release Mr. Davis to treatment.
The
Mr.
court will
Davis,
sign that order if,
I do have it's non-stipulated. I don't want to speak with Ms. Feltus. She said she'd leave it in the court's discretion.
all right, then I'll sign the order.
Okay.
I'll grant your motion. Adjourn this to November 5th, 2025, 9 a.m. And I'm signing the order for release to treat inpatient treatment.
Thank you, Your Honor.
Thank you. Oh, okay. Court calls the case People versus John Neary.
Ashley Phelps for the people.
Assistant Public Defender Natalie Pate with on behalf of Mr. Neary, who stands to my right. Please state your name for the record, sir.
John Neary.
Thank you, Your Honor. Make the prosecutor and I approach.
Okay.
Thank you, Your Honor.
Mr. Neary wants to get out to a blind, so I'm just.
I don't drink. I don't.
Why? Oh, okay.
Every courtroom starts quiet, too quiet. But beneath that silence, 100 stories fight to be heard. The judge adjusts their glasses, the defendant avoids eye contact, and everyone pretends not to know how this will end. But the air knows. It's heavy with secrets, confessions, and consequences. One word can free a life or destroy it forever.
Seven. Our record should reflect we've had a bench conference in this case. I'm going to, counsel's explained to me some things, Mr. Neary, and just with you and your family the best. Okay, sir?
Yes, sir. I appreciate it.
I'll adjourn this to January 7th, 2026.
Yes, sir.
At 9 a.m. And the reason I remember you remember our last interaction when you first came in, Mr. Neary?
Yes, sir.
You
on
remember?
the deer hunt.
Yes, no, you were. I didn't know what you were going to do. You were like kind of angry and just telling me you were a hunter, and I'm like, okay, I get it. No, I get it. You started out. Hold on, no, I remember because when I saw you, out of all those people,
I trimmed my beard.
I
trimmed my beard.
Yes, you did. But I recognized you. I said, that's him.
Yes, sir.
And so I was trying to figure out a way I was going to do this. And then it was bow season. And I said, okay, we're going to let him shoot with bow. And then I remember the only thing that calmed you down was me telling you were coming back on the opening of firearm season, and I'd address it then. Then you said, okay.
Yeah. I won't be doing it this year, though. I mean, I've got prior.
Well, yeah, and I understand why, and again,
Yes, sir.
you'll be in our thoughts and prayers, all right, sir?
Yes, sir. Thank you.
What I am gonna do is, and I know you got more important things to take care of, but because sometimes while you're doing that, you may need a break. All right, and maybe you won't, but maybe you do. So what I am going to permit is I'm going to permit him to possess a firearm in case he just wants to go out and just maybe clear his head.
My wife's more important, though.
What?
The wife's more important.
Oh, I know,
That's what I
but
gotta do.
sometimes maybe you just need to
Mentally, yes, sir. I understand.
So I'm
Mentally,
just,
yes.
you don't have to do it. I'm just allowing it.
Yes, sir.
Okay.
I deeply appreciate it. I really
All
do.
right.
Thank you so much.
You take
Thank you,
care of
sir.
yourself and,
Okay.
give your wife my best. I haven't met her, but.
I will do it. I will do it. Thank you,
All right,
sir.
Thank you, Your
very
Honor.
much.
Court calls the case People versus Taylor Meyer.
Conrad Solar on behalf of Pittsfield Township.
Good morning, Mayor. Please score your honor. Attorney Damian Caspi, number 85852 on behalf of Mr. Taylor Meyer. Just on my right.
Your name?
Taylor Meyer.
All right, what are we doing?
And here we are here for a pretrial and a bond violation. To the bond violation, he pleads guilty. To the
He'd admit to the bond violation.
he admits to the bond violation, Your Honor.
Is
And
that correct, sir?
yes, Your
You don't want a hearing?
no hearing, that's it.
Right. All right. Go ahead. What are we doing as to?
And to the pretrial, we've been presented an offer, and we would like to accept if the prosecutor needs to place it on the record.
Your
Well,
Honor, it's just my understanding that he's gonna plead guilty. I've approved him for a deferred sentence, and that's the agreement.
all right. We need to make sure to get plea forms in because I know.
I will submit the plea form to the court afterwards with Mr. Cash's signature, or we can adjourn it.
I'll get permission to
Is he
sign.
being held on anything else?
Nothing else, Your Honor. And as I would ask for a release, his brother has been notified to come pick him up if he's released today. If not, obviously to the discretion of the court.
Why were you missing your test?
Why were you missing the test?
I was in Traverse City.
So how am I going to make sure if I release you that you're going to test?
I will go to the one that I was able to go to.
Has he signed an advice? Never mind, sir. Have you signed an advice rights form?
She's been tendered his vice versa. I was just presenting it.
Well, I'm not going to rush this. I'll take the plea, but I'm not going to do it today. I need the form. I need this stuff done as I asked it to be done. So I need the form, his vice rights form, and everything to the court, and I'll be more than happy to take his plea. I'm adjourning this out to my next date of November 5th.
November 5th.
Mr. Cash, I'll email you the form tomorrow.
2005, 9 a.m. To start down that path, and I just don't get the paperwork that I need. Bond continue. Thank you. Court calls the case, People versus Shadira Akiji.
He's in custody. We're down to just.
Oh, we're just down to the, okay, gotcha. If you want to throw some of the 11s in here, I could just start on those. I may not be able to get through them all, but whatever one. Because otherwise people will be waiting for these.
Mr. Stiller, this is your case, I think. It's EKG.
Thank you. Conrad Solar on behalf of Pittsfield Township.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. EKG. State your name for the record, sir.
Chitra Bennett, the cage.
All right.
Oh.
What are we doing?
Just trying to get it right. We're asking for an adjournment, Your Honor. This is a no registration case. We believe the car has been sold, so I just need time to get that from Mr. EKG's family to Mr. Stiller.
November 5th, 2025, 9 a.m. Bond continued.
Thank you.
Court calls the case People versus Kurt. Is it Bushland?
Oh, Ashley Feltus for the people.
An Assistant Public Defender, Natalie Pate, with and on behalf of Mr. Bushlane, who is present via Zoom. Sir, can you please state your name for the court?
Yes, Craig James, Bushline.
All right. What are we doing?
Thank you, Your Honor. I have had the opportunity to discuss this case with my client, and at this time, we're asking to set the case for final settlement conference.
Jury final settlement conference will be December 5th, 2025, 9 a.m. Jury selection, if necessary, December 8th, 2025, 8:30. Both of those proceedings are in person.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Mr. Bushlane.
Yes, ma'am. Do I get a letter from you?
Court calls the cases of the People versus Paris Lester.
Conrad Solar on behalf of Pittsfield Township.
Ashley Feltus for the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Lester. State your name for the record, sir.
Paris Lester.
You know, we're close to a resolution. We're just need to nail out some details. So I'd ask for an adjournment. I think the 5th should be fine. Mr. Lester is being held on a sentence for the next couple of months.
November 5th, 2025, 9 a.m. on all.
Thank you.
Thank you, Bond. Continue. Court calls the case People versus Brandon Nash.
Ashley Feltus for the people.
Your name, sir?
Brandon Nash.
Good morning, Your Honor. My name is Sam Fisk, and this is my partner, Melanie Lemus. We're student attorneys with the University of Michigan.
You're kidding.
We are not.
You're kidding. I'm shocked. They're student attorneys, Alan. No, go ahead.
We are requesting permission to practice under MCR 8.120 under the supervision of Sarah Sal.
Good morning, Mr. Allen. So, hold on. You haven't spoken before?
Not yet.
You did all the talking,
Yeah.
right?
Yeah.
Why?
He was in class.
Is he? Oh, he was in class?
And he was scared.
Oh, that's not what she said to me. She said you were going to mess it up. Okay. That's why he's not here. Where are you from, young man?
I grew up in Hartford, Connecticut, sir.
Connecticut?
Yeah.
Oh. Where'd you go to undergrad?
I went to Claremont Mechanic College, Your Honor.
Where the hell is that? I mean, where's that?
California, Your Honor.
So you left Connecticut, went to California.
Yes, sir.
And now you're here.
Yeah, I lived abroad for a year and now I'm here. So I took the scenic route.
Lived abroad where?
I was at the University of Cambridge, Your Honor.
Excuse us. You see that? How he just threw that up in there. I was abroad. He wasn't going to say why.
Candor with the court, Your Honor.
No, that was good. So he went to Cambridge. He started in Connecticut, went to Cambridge. Well, then California. And now you're here. So when you're done, you're not going to stay here.
I'm going back to California, Your Honor.
So why don't you just go out there?
I got into Michigan, Your Honor.
That's not a big deal. Anyway, speaking as a Maryland grad. All right, permission to practice is granted. I'll let you go ahead.
Thank you, Your Honor.
On behalf of your partner, don't mess this up.
Fingers crossed, Your Honor. This morning, we're seeking an adjournment.
Yes, go ahead. Why?
Well, we're still waiting on discovery in a case with a common nucleus of facts. So we're waiting to hear from the other attorneys
Did he
in that
do
case.
some Latin there? What'd you say?
from a very related case. We're still waiting on discovery.
What? No, what word did you use?
Common nucleus of facts.
Garen, did you know what he meant?
I couldn't understand what he said.
I didn't get it. He was like, he might as well have done it in French because I wouldn't have understood what he was talking about. Oh, so common nucleus. It's like I'm in a science class. All right, fine. So you're waiting on discovery on that?
Yes, Your Honor.
From where?
From the attorney related in the felony matter.
Oh. Is it the public defender that's representing him on the felony?
I believe so, Your Honor.
No? He got it wrong.
Oh, okay.
He got it wrong.
Apologies.
See, selling back there. So you're just waiting to get some information?
That's correct.
Okay, so how much time would you need? She is so thankful she's not up today. How much time did you need?
We would be interested in working towards the final settlement in December, if that's possible. We believe the next one is on Friday or so, and we think that the final settlement in December is appropriate.
Wow. South, is there anything you want to say on this?
If we are hoping to resolve these matters short of trial, I would recommend determining pre-trial rather than proceed to final settlement conference.
So what do you want to do? Don't look at her. You're up. She had to do it on her by herself and did a fine job.
Thank you.
We believe a 2-week adjournment would be appropriate.
So you can do it by November 5th? Or do you want November 19th?
More time would be better, Your Honor. So November 19th.
No, you don't even know that. Miss Sullivan, what date would you be available? It was the 5th or the 19th. Boy, oh boy, he's just, you want to know why it's that Cambridge education?
Your Honor, the 19th would be preferable.
Thank you. Will that work with you?
Yes, Your Honor. Thank you.
Of course, you're a student. You're not doing anything.
Yeah.
Mr. Nash, don't get nervous. You're in good hands. You good?
I like you.
Huh?
I like you.
Him?
Love the sense of humor. You.
Oh, me?
Yeah.
Oh, yeah, I like me too. What do you think about him? No, don't say it.
Your Honor, additionally, we'd like to request a Zoom proceeding if possible. Brandon has to travel 2 hours from Kalamazoo for these proceedings. And it'd be easier for him if we could do it remotely.
Okay. We all know how that's done.
If I may, Your Honor, you wanted him to be present in court?
That is correct. So, but I think that was because of his testing.
That's right.
And I'm a little bit worried about that. I'll get to that. November 19th, 2025, 9 a.m. as your invite indicates. I'll adjourn it to that day. Do I have new test? I have October 8th. He's got results pending on his ETGA. Do you have a medical marijuana card?
No, sir.
And why do I have THC in your system?
Your Honor, honestly, I was a heavy smoker, but when you said don't smoke no more, I did not smoke. I was calling the drop line every day, and my levels have been coming down.
Lundy.
The defendant is on parole.
Got it. That's right.
We had come, I think the court calls out, we had come and we had talked about him being an absconder at the time that he picked up 2 retail frauds in Washtenaw County. And the court very graciously has given him PRs in this case, as well as the felony, which is not before the court today. But that's of great concern to the people.
But my understanding is he was on, but I thought his absconder status, he's rectified that issue.
Correct. That is correct. But I still think he's on parole at this time.
Is that correct? You're still on parole?
Yes.
And you can't use while you're on parole?
Honestly, they don't test for marijuana on parole. But when you told me to stop smoking, I stopped. And my levels came down, like you said, last via Zoom. And I'm just on the right path, honestly.
All right. If you submit the proper paperwork, I'll allow a Zoom proceeding provided I don't get a positive test. If I get a positive test, you're going to need to be here. Understood?
Yes, sir.
All right. Anything else?
No, Your Honor. Thank you.
Sure?
Positive.
Is there anything else? Or is, no, I'm asking you. Because you know what's going on. Is there anything else?
No.
Is he good?
He's
All right,
good.
we're good. All right, thank you.
you.
Fine, continue. That's okay. He's from Cambridge. Court calls. Don't talk to him. Court calls the case People versus Christopher Minor.
Conrad Solar on behalf of Pittsfield Township.
Kara didn't step anywhere near that. I don't know what that.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Minor. Mr. Minor, state your name, sir.
Christopher Minor.
Thank you.
Your Honor, Mr. Minor would like to set this case for final settlement conference.
All of these?
Yeah.
People think justice is blind. It isn't. It waits, patient and ruthless, watching from the bench while time exposes everything. Lawyers change tone, witnesses break, and evidence finds its voice. It might take hours, days, even years, but when justice moves, it doesn't miss. It just arrives, and it never leaves quietly.
What? What was that?
Well, I forgot that there were Mr. Siller's cases, to be frank. No offense, Mr. Siller. I think, actually, can we ask for one more adjournment? We'll resolve Mr. Siller's cases, and if Mr. Minor still wants to set the state case, we can set it at that time.
Okay.
Does that make sense?
Well, I understood you. Whether or not it makes sense or not, I don't know. I'll adjourn everything to November 19th, 2025, 9 a.m. I'm presuming he's held on something other than me.
Yes, he's being held on his probation violations at Judge Hamoud's court.
All right. Is there a hearing on that setting time soon?
Do you know when we're going to see Judge Hamoud again?
That's okay.
Yeah.
I'll just adjourn it out to the 19th. And then we'll go from there. And if his bond changes on that, certainly you know how to get in touch with the court. Thank you.
It looks like the 3rd and the 11th and the 3rd. No, the 16th and the 3rd. So
Got it. Okay. Court calls case People versus Eric Burton.
People.
Good morning, Judge Kyle Burdell on behalf of Mr. Burton, who's approaching the podium. Mr. Burton, please introduce yourself to the court.
Hey, good morning, sir. My name is Eric Burton.
Thank you.
Your Honor, today is the date and time set for pretrial. We are asking that the matter be set for final settlement conference.
Jury final settlement conference, December 5th, 2025.
Thank you, Judge.
Was that Perry again? Bless you, whoever that was. Oh, that was you? Man, that was loud. No, I'm just kidding. December 5th, 9 a.m. Jury selection, if necessary. December 8th, 2025 at 8:30. Both of those proceedings are in person.
Thank you, Judge.
Thank you. Have a good day. Court calls the case of the People versus Robert Moyle.
Conrad Solar on behalf of Pittsfield Township.
Public Defender Natalie Pate with and on behalf of Mr. Robert Moyle, who stands to my right. Please state your name for the record, sir.
Robert Moyle.
Thank you, Your Honor. I'm asking for an adjournment of this matter. Mr. Moyle is serving a sentence and being held until April of next year. I did speak with him regarding this matter, and I need to contact a nephew of his to obtain some potential documentation.
You know what? Given that, if he wants to admit double parking today, he can do that.
Oh, then I think he would want to do that because that was what we were going to be doing with the documentation. So,
right.
Was that something you want to do today instead of at the adjourned date, Mr. Moyle?
If we want to take care of it today, let's do it.
All right, perfect.
Is that what he wants to do?
Yes,
So, Your Honor, I moved to add count 2 of double parking. you accept that admission, move to dismiss the original charge.
Absolutely.
I saw Jimmy's numbers. Okay.
And so, sir, do you admit responsibility to the fact that on February 20th, 2025, location of Washington Avenue in Pittsfield Township, that you double parked a motor vehicle?
Absolutely, sir.
All right, court will accept that admission. The double parking count 2, count 1 is dismissed. Fines and cost in the amount of $180. That will be payable 90 days after release.
Thank you.
All right. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus Michael DeWitt.
Ask calls for the people.
Morning, Your Honor. Dan Garrett on behalf of Mr. DeWitt.
Michael DeWitt.
Your Honor, for arraignment, we would waive reading and stand mute, please.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea.
Another pretrial date, Your Honor. I still have not gotten discovery.
All right. 5th or 19th?
19th, please, Your Honor.
Turn this matter to November 19th, 2025, 9 a.m. As to found in this case, I will think it's, you may want to make sure you get your appearance in. I don't know why it's not appearing, but.
Yeah, we just filed it yesterday, so it may be lag time.
That may be why. Set his bond at a $5,000. Personal recognizance. Order standard conditions, including no assaultive behavior or possession of any weapons. There's to be no use of any alcohol, recreational marijuana, or any illegal drugs. Any reason you need to have contact with Joshua Wade?
No, sir.
I order no contact with Joshua Wade. All right. I trying to figure out, is it?
We did not request a no-go to your.
That was because it was at Costco. Right.
I'm sorry?
There's a no-go to, but the event occurred at Costco. So
We did. We didn't ask for a no-go to Costco, but the court.
Well, I'm not gonna necessarily order that unless it's connected to that.
You order my wife not to go to Costco?
What?
Can you order my wife not to go to Costco?
You know what? I'm not even getting into that conversation.
All right,
No, she should. Okay, no, I'm gonna. You see, you brought me into it. She gets to go all the time.
Well, I'm gonna work till I'm 90.
And to your lovely wife, spend as much money as you want.
She does.
Wow. Karen. Wow.
Thank you, Your Honor. Have a good day.
No, you're in trouble yourself. All of us are sticking up for her.
Yeah,
you are alone in this one.
Thank you.
Have a good day, Your Honor.
Thank you. Thank you, sir.
Thank you.
Court calls the case, people versus Thomas Sharon. Wow, Karen. I'm sending her the tape.
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Sharon. State your name for the record, please, sir.
Thomas Sharon.
Your Honor, Mr. Sharon, we're asking for adjournment. Mr. Sharon has a case in 15th. We're hoping to get a global, resolve all of these cases together. The 15th case is really what's holding him.
Yeah, when is that set?
I think it's set for, did we talk about tomorrow? I think it's set for tomorrow.
Okay, so why don't I adjourn this then out to November 5th, 2025, 9 a.m. Both of these matters.
Thank you.
Thank you.
We'll be in touch, okay?
See you tomorrow, I guess.
Court calls the case, people versus Candace Brooks.
People. Good morning, Assistant Public Defender Lauren Perry on behalf of Ms. Brooks. Ms. Brooks, say your name for the record.
She's in Zoom.
Good morning, Candace Brooks.
Thank you.
Your Honor, I am asking for hopefully one last adjournment. We do have a resolution. Miss Brooks is on probation in 14B. I just hope to be able to see if we're able to coordinate her probations with this probation and that probation, or see if things can be applied here.
Streamlined so that she
Exactly.
not doing November 19th, 2025, 9 a.m.
Thank you.
Bond continued. Thank you. Court calls case People versus Sherry Ann Walker.
People.
Good morning.
Morning.
Speaking of budget. Assistant Public Defender Natalie Payton on behalf of Ms. Walker, who stands to my right. Please state your name for the record, ma'am.
Sherry Walker.
All right. I have before me a plea form. Is that what we're doing?
Yes, Your Honor.
Plea form indicates that she's going to be pleading no contest to the charge of retail fraud in the third degree, the 93-day offense. On her successful plea to that charge, count one would be dismissed. That's the court's full understanding of it.
Yes, Your Honor. That's correct, Your Honor.
May I have her sworn?
You solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
State your name.
Sherry Walker.
It is this court's understanding you're going to plead no contest to the charge of retail fraud in the third degree. That is a misdemeanor. It is punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken is greater than $500. You understand that?
Yes, sir. Yes, sir.
Okay. Do you understand what a no contest plea is?
Yes, sir.
All right. 2 things I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, sir.
All right. Basis for the no contest plea?
Potential civil liability.
To the charge of retail fraud third degree, how do you plead?
Guilty.
Really?
Guilty or no contest?
No contest. I'm sorry.
All right. You understand that by pleading no contest, you will not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, isn't that correct?
Sir.
Any question regarding those rights?
No, sir.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving, or pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No.
If I'm there, no.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily
Yes, sir.
and of your own free will.
Yes, sir.
Court has been provided and has reviewed Pittsfield Township Department of Public Safety report for their case number 23-18413. Any objection to the court having reviewed that report?
No, Your Honor. No, Your Honor.
Reviewing that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined under the Michigan court rules, that the court would no longer be bound by any sentence evaluation and you would not be entitled to withdraw your plea. You understand that?
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this?
No, Your Honor. No, Your Honor.
All right. And you okay?
Yeah, I'm sorry. I feel like I'm coughing. It's awkward here, so I'm just saying.
And have I complied with the court rule and would it be proper to accept this defendant's plea?
Well satisfied.
Yes, Your Honor.
All right. If you couldn't answer parody, whatever.
That would have worked out.
This happens that way. All right. Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter. Is she held on anything else?
Yes, Your Honor.
November 12th, 2025, 9 a.m. All right.
Thank you.
Thank you,
Ms.
Your Honor.
Walker. On continue. Court does call the case. Court calls the case People versus Correll Brown.
Good morning, Assistant Public Defender. Ashley Phelps for the people. Lauren Pearney on behalf of Mr. Brown. Mr. Brown, state your name for the record.
Correll Brown.
Yeah.
Your Honor, we have a resolution. I just need to coordinate with Mr. Brown to get all the paperwork signed. So, I'm asking for hopefully one last adjournment.
November 5th, 2025, 9 a.m. Bond continued. All right, thank you. All right. Thank you, Mr. Brown.
Thank you.
Court calls case People versus Jessica Yoder.
People. Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Yoder. Ms. Yoder, state your name for the record.
Jessica Yoder.
I knew that.
No, thanks.
Well, we think this is the last case that has to be resolved, right?
Yes, it is.
It is?
Yes.
I'm not going to believe it until she just doesn't show up. So. I'm just.
It is.
It is?
I see you for sentencing next week and I'm done.
Really?
Yes,
Oh, it's been a long haul.
it has. Did you sign my release to treatment?
Whoa. You see how she did that?
She
I'm
knows.
not going to see you again, but you do what.
She knows what's going on.
Signing it.
Judge.
No, I'm not. I'm going to do what I want to do.
Then I'll just pay the $300.
What did you say?
Then I'll just have to pay the $300.
What is that, Miss Parody?
So,
Is that a release of treatment?
yeah, it's stipulated, this one.
It is?
It's on.
But it's stipulated, but you're still going to talk about it.
I will say, well, it's on behalf of me and Miss Constantino, because Miss Constantino has one of her cases that's scheduled for sentencing. I did submit it, but then I messed up a case number, I think. So this is the accurate.
Never take responsibility for something you don't have to. Just say I submitted it, but there was an error. You could have blamed it on Constantino.
I mean, Anne caught it for me, so.
And
But you look like you have a thought.
There was an error in a case number, and then there was one case that didn't belong on the document as well.
Yeah, one I think was dismissed. The ROA, I don't know if it's updated, but Judge Freshour.
I'm going to keep talking.
It was not clear on the ROA if it was dismissed, but it was dismissed in front of Judge Freshour on the record.
Is this good? Because she said a lot there.
Yeah, I think so, because it was a 14B case, right?
Oh,
Yeah.
that shouldn't have been on.
Yeah. And I will say on behalf of Ms. Gooder, she's in recovery court before Judge Washington. So Judge Washington is reinstating her probation and releasing her to treatment.
Yes.
Yeah, let's have her sworn. She knows the routine.
Do you solemnly swear the testimony you're about to give the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
Jessica Yoder.
Okay, Mr. Yoder, it's this court to understand you're going to plead guilty to the charge of retail fraud third degree. That's a misdemeanor. Punishable by up to 93 days in jail, $500 fine plus court cost. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum sentence or the maximum fine. You understand that?
I do.
Still wish to plead guilty?
I do.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5 on that form. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole? Or are you on at the time of this?
At the time that I heard that, no.
Okay. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes, I am.
Of your own free will?
Yes.
Because you believe that you are indeed guilty?
Correct.
July 24th, 2023, at location of Walmart, Pittsfield Township, Washington County, State of Michigan. What'd you do that makes you think that you're guilty?
I attempted to take merchandise that was for sale.
Oh, you took some merchandise.
I attempted to take merchandise. I attempted to.
All right. Store was open to the public at the time?
Yes.
You didn't have anybody's permission to take that property, did you?
No, I did not.
And as indicated, the property that you took was property that was off sale by Walmart?
Correct.
All right. If I accept your plea, if between the time of plea and the time of sentencing you commit misconduct as defined in the Michigan court rules, any sentence evaluation or recommendation, the court would no longer be bound by, and you would not be entitled to withdraw your plea. You understand that?
I do.
Counsel, are you aware of any other promises, threats, or other inducements which would cause this plea?
No, Your Honor. No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
People are satisfied. Satisfied, Your Honor.
Court will accept the defendant's plea to count 2. Count 1 is dismissed. Defendants referred to probation for pre-sentence investigation and report. You're set for sentencing before me when?
Next Wednesday on the 22nd.
22nd. That means they will have all of. So I'll set your sentencing that for this one that same date.
Thank you.
Instead of the other date for October 22nd, 2025. That's at noon, right? That's a noon start time. Okay. Bond will continue, Ms.
Thank you.
Carter.
Thank you.
I'll see you again on the 22nd.
Thank you.
You know what? I will say this. For whatever the reason is, you are a much more pleasant person than the person that I first met when you came in. Right?
Yeah.
Okay. Take care. Court calls the case People versus Leslie Brown.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Brown. Mr. Brown's statement for the record.
Oh, there it is.
Leslie Brown.
Thank you, sir.
Your Honor, we are requesting an adjournment for plea negotiations and for Mr. Brown to review discovery.
All right. I'll put him up. November 19, 2025, 9 a.m.
Thank you, Your Honor.
Bond continued. Thank you, sir.
Thank you. Thank you.
Court calls case People versus Devon Julia Martinez.
Conrad Siller on behalf of Pittsfield Township.
She is refusing again to come out.
Understood, Your Honor.
Participate.
I would I would respectfully request an adjournment in that case.